So under the statute, under subdivision 2B1, the ballot board has to be satisfied that the voter's name is the same. The name on that signature envelope is the same as the information provided on the application. But the rule says that the ballot board can't use the fact that the name is different due to the use of a nickname as a reason for rejection. That seems like a conflict to me. I mean, it just seems like the statute says the ballot board should look to see if the name is the same. And the Secretary of State's rule is saying you're not really looking to see if the name is the same, because in fact the name can be different. If you use your full name on the application but you use a nickname on the envelope, your name is the same. That feels like a conflict to me. Now maybe is that really what the Secretary of State wants the law to be, that it can be anybody, it doesn't have to be the voter?
No.
Okay.
No.
I mean, that argument just feels a bit extreme to me.
What if, I have my parent living with me, they forget to vote, I see the absentee ballot sitting on the counter and decide I'm going to vote that one too. I mean, none of the scenarios you talked about address that.
No, so in that instance, yeah, so you'd cast their vote on I guess it would depend on the timing. First of all, I mean, if you see they forgot their ballot, it's election day, you could there'd be timing issues with getting it in time. But putting that aside, in that scenario, you would still be committing the felony though of voting on someone else's behalf.
But how would you ever find that out?
It would be difficult. Don't
Fundamental
match.
problem here that none of this deals with. The fundamental problem is that absentee voting in any context creates ballot security issues that are not present when you vote in person.
That's true. If a ballot board member went off on a wild hair and said, I'm going to bring in 2 divining rods and read the aura of each signature, and one of them's blue, one of them is red, and I'm going to reject them even though they otherwise look identical, under appellant's view, there would be nothing to prevent that.
Mr. Dickey, when you're ready, could you just address that last point about how there wouldn't be any limiting principle on the election judges who would be comparing signatures?
Yes, thank you, Your Honor. So there would be limiting principles. First of all, the legislature has asked to compare signatures, not to compare auras or to look at the color. It's the members of the ballot board who are reviewing the ballot, not the one person. And there has to be a majority that agrees to accept or to reject a ballot. So if you have one person who is not particularly well fit to be a ballot board member and decides to compare auras, for example, that would not carry the day. Signature matching itself is a uniform process. What the Secretary is advocating for is uniform outcomes, not a uniform process. Signature matching is a uniform process. This court has expressly approved it and also required that those who are exercising the privilege of absentee method of voting to exercise their fundamental right to vote must strictly adhere to the requirements for absentee voting. So again, adhering to these strict standards, including signature matching, what it means to match signatures, is a uniform process statewide, and it's not going to result in substantial disparities across the state, especially when you do have the ability to look at a ballot and say, okay, well, the identification numbers do match. You have a voter record in front of you. There's signatures that are in that voter record, like we talked about earlier, if the person has signed anything before. So there are a lot of different safeguards that prevent the situation, the parade of horribles that the Secretary has raised.
Could you respond to the Secretary's argument that if we adopt your interpretation, the statute would violate federal law?
Absolutely. Yeah, there's, again, 32 states have signature matching requirements. What the courts that have struck down different signature matching requirements under the Voting Rights Act have said, and there's, I think, 2 cases that I've seen, or maybe 3, but the ACLU in their brief put together a list of different cases where there were concerns about, some of the cases were concerns about signature matching. We have a footnote in our reply brief that I would point the court to that exhaustively goes through every single one of those cases and points out reasons why that's not dispositive in this case. But also, I mentioned in my previous argument that there is significant, robust safeguards in Minnesota law to protect against a violation of the Voting Rights Act. And specifically, there are notice and cure provisions. And I've got a couple examples that I'll provide the court. Again, these are in our reply brief, but I think it's worth noting that if a ballot is rejected before 5 days before the election, that the ballot board must promptly provide a new ballot. And if it's rejected within 5 days, the ballot board actually has to call, has to email, has to do whatever they can to get a hold of the person to let them know that their ballot could be rejected because of a signature mismatch. And absentee ballot board members are constantly, from the start of absentee balloting, 46 days before an election, they are constantly, within 5 days of the time a ballot gets in, they're reviewing it. So there's a timely, rolling basis in which they were reviewing signatures or reviewing, whether it's signatures or identification numbers or both. They're reviewing them constantly in that 46-day period. Those provisions under Minnesota law are simply non-existent. Like, for example, I think in Indiana was one of them, and in Florida. So we just have a different law here. This concept of somehow the voter means can only mean literally the same person who requested the ballot. We've not said that in our briefs. We recognize under Minnesota statute 645.44, which would apply in these situations, that a person who has a writing disability, who cannot write their own name, can use a mark, can use a stamp, can have someone else sign. And that, under the statute, is expressly stated that signature is adopted for all purposes by that person. So it is the voter's signature. Our position simply is that under 2B3, for example, when you're comparing the application and the return envelope, and you've got a mismatch identification number, that you have to have the same person signing both. That it has to be the same signature. So if a person provides assistance to another person, that you'd have to have the same signature between the application and then the return envelope. So there's really this whole the voter thing. We're certainly not taking away the ability for people with writing disabilities to get assistance with their ballots, and that would clearly violate this court's decision in Ray DSCC, which was just decided.